Good afternoon once again. It is an important announcement. I give the mic to the president.
Good afternoon, friends. Respected today's speaker, Advocate Deepak Bapat sir, LNR Committee Chairman, Advocate Dinesh Tambre, my office bearers, Joint Secretary Vinod Maske, LNR Committee Convener Sunil Joshi, and all the delegates presented physically and online. Before starting our third study circle meeting, today we heard the very sad news about Praveen Bhai Shah. He is our past president. He expired today morning around 11 o'clock. प्रवीण शाह ये उनका क्रिमेशन है वो पार्ला में है 5 बजे. उनको श्रद्धांजलि जैसा हिंदू संस्कृति में है, क्रिमेशन होने के बाद ही अपन श्रद्धांजलि देते हैं. तो अपना कल एक सेमिनार से एमसीएम भी है आज शेड्यूल, वो होने के बाद एक श्रद्धांजलि अर्पित की जाएगी प्रवीण भाई शाह को. We also plan to organize the separate condolence meeting of the Praveen Bhai Shah. His cremation at a Vile Parle. Effective from 1st October 2023 under the GST Law. For that, we have a learned speaker, our past president, our seniors, Advocate Deepak Bapat sir. He will going to enlighten us on the topics. I welcome you all once again for this third study circle meeting. Tomorrow, we will have the organized half-day seminar jointly with Malad Chamber of Tax Consultants at the Borivali after post-lunch. Advocate Parth Badeka and CA Vikram Mehta will going to speak on the ITC and import of services issues respectively. I appeal our esteemed members to enroll for the same and take the benefit of the seminar. We have submitted a representation to the state commissioners, and after submission, immediately commissioners invite us for the discussions. I request our chairman Dinesh Tambre sir to take the elaborate the what happens, what the proposals to the members in his speech. I request Dinesh Tambre sir to elaborate the same in his speech. We have submitted the PT periodicity representation and the VAT amnesty. I also announced our RRC. The RRC is the dream project for the presidents and all the members of our associations. This time we will plan to hold the RRC at Vishakhapatnam. This is the untouched destination for the GSTPAM. Vishakhapatnam, Vizag. This will be held from the 29th February 2024, 29 February 2024 to 3rd March 2024. They organize this event at Hotel Novotel. It's beach property. The sightseeing also very nice there. Submarine museum, aircraft museum, Kailashgiri Parvat temple, and Simachalam temple. These are the sightseeings over there. My chairman Sachin Gandhi and convener Dilip Nathani, Ajay Talreja, Premal Gandhi, all are working on this. The detailed circular and enrollment form will publish on our website and our WhatsApp group very soon. I appeal all the members from the all over all the corner of the Maharashtra to enroll for this RRC. मेरा पहले से डिसाइड था कि आरआरसी करना है अनटच डेस्टिनेशन, जहां पे हुआ नहीं आरआरसी। और ये विशाखापट्टनम जो वाइजैक जो सिटी है, नीट एंड क्लीन सिटी है। साइट सीइंग, ये जो प्रॉपर्टीज है नोवाटेल बीच के ऊपर प्रॉपर्टी है, तो एक सेटिस्फेक्शन जो मिलेगा वो, मैं प्री विजिट के लिए हम लोग गए थे हमारी टीम, तो देख के हमने वो होटल फाइनल कर दिया। बहुत सुंदर होटल है, हॉस्पिटलिटी बहुत अच्छा है, साइट सीइंग अच्छा है। तो आई अपील ऑल द मेंबर्स टू एनरोल एज अर्लीस्ट एंड बुक योर फ्लाइट टिकट एंड ट्रेन टिकट। आई अपील मेंबर्स टू majority of the delegate join train. This is we'll try to because flight tickets बाद में हाई हो जाएगी, इसके लिए हम ट्रेन का सोच रहे हैं। 36-37 आवर्स जर्नी है, तो एंजॉय करके जाएंगे, जैसा पहला अपना आरआरसी जाता था वो हिसाब से मेरा प्लान है। वी ऑल्सो inaugurate our Marathi coaching class and Gujarati coaching class. We started this last week. We have received good response for this Marathi coaching class and Gujarati coaching class. मुझे प्राउड फीलिंग हो रहा है कि मेरे टेन्योर में गुजराती कोचिंग क्लास स्टार्ट हो रहा है, और नेक्स्ट ईयर से अच्छा रिस्पांस मिलेगा, क्योंकि मेंबर्स नॉट अवेयर, बिकॉज जीएसटीपीएम एक्टिविटी करती है गुजराती में। तो आई थिंक नेक्स्ट ईयर जो प्रेसिडेंट हो जाएंगे उनको सब ये बेनिफिट मिलेगा। तो ये मराठी एंड गुजराती कोचिंग क्लास वी हैव good response around Marathi coaching class enrollments around 140 plus, and Gujarati around 60 participants. Okay. Our outstations, regarding outstation seminar, we had attended the outstation seminar at Nanded on 8 October 2023. And in the pipeline, the new seminars at the Latur and Solapur, that will be scheduled on 28 October 2023 at the Latur and 29 October 2023 at the Solapur.
Praveen sir, no sound, please.
यासाठी मी अभ्यासू व्यक्तिमत्व कोण आहे याचा मी जरा विचार केला आणि खरोखर मला वाटलं की दीपक बापट सर ह्या सत्राला योग्य तो जस्टिस देतील आणि खरंच देणार ते. मी दीपक सरांचं बापट साहेबांचं मी आभार व्यक्त करतो की तुम्ही आमचं आमंत्रण स्वीकारलं त्याबद्दल बापट साहेबांचा आभार व्यक्त करतो. आणि मी या कमिटीचे चेअरमन दिनेश तांबे सर, कमिटी कन्व्हेनर सुनील जोशी सर आणि आदित्य सीमा त्यांचाही मी आभार व्यक्त करतो. कारण LNRT खूप चांगल्या पद्धतीने काम करत आहे. ज्या गेल्या 2 ते 3 दिवसामध्ये ज्या घडामोडी घडल्या ते तांबे सर त्यांच्या भाषणामध्ये बोलतीलच. मी पुन्हा एकदा सगळ्यांचं स्वागत करतो आणि धन्यवाद देतो. जय हिंद, जय महाराष्ट्र, जय भारत.
Thank you, President sir. मला सर बोलल्याबद्दल. Okay. I have been requested by the President to elaborate on what representations that we have made and what is the outcome of that. First outcome, you all must have seen that we have been given an amnesty for the appeals which were time barred. So now the orders, the orders by the adjudicating authority, if that have been passed up to 31st March 2023, for that we can file appeal against that orders. We can file appeal up to 31st January 2024. So this is what is being. I think our President deserves a big round of applause for this. This representation, we continuously were following up with the Commissioner. We had elaborate meeting with the Commissioner, and I think we should applaud for the Commissioner also, because getting this kind of relief from the central government in CBIC is difficult job. So many officers told us, especially Mr. Khanan, they told us that our Commissioner has played a great role for bringing this amnesty, and the benefit of this has been given to all the across India. So Maharashtra has played a great role in bringing this amnesty, and especially our association and the Commissioner. So we must thank both President and the Commissioner. Thereafter, we have made one more representation for which we had an elaborate meeting with the Commissioner and his team regarding the profession tax returns, that the first year of the profession tax return, the periodicity is not available on the portal. And for that, the assessee of the practitioner has to run pillar to post for getting that periodicity set. They had called NIT people. We, in front of us, he basically told in the harsh words that these things should not happen to those technical people. And they have requested us. Actually, we lack in that. Every time when we make a representation, we want that our members to give their live cases, such live cases with their PT number, etc. Now they have asked. Actually, we had been given only 3 days to give that data. We only had said that our convener will prepare that data, but he is also helpless if you don't give those TIN numbers or the PT numbers in which the periodicity is not set. So in the cases, the first year of registration and thereafter also in some cases periodicity is not set and we are not in a position to file return. So this kind of cases, they have said that give us list, we will take appropriate, come out with the appropriate solution. This is one aspect. And we have requested the Commissioner to extend the amnesty, which according to them, they are not getting good response. Actually, the cases which were required to go in amnesty, the major chunk has gone in the previous amnesty. So it is but obvious that there would not be there will be very few cases which will go in this amnesty. So they say that we have come out with the amnesty and you are not responding it in the satisfactory manner. we had no answer actually to this, but those people who wanted amnesty, they are going, and there are actually huge amount of the liabilities which are to be settled by the requisite amount. And for installment, it is obvious that people will go run at the last moment, because that installment will start from the date of the first installment. Subsequent quarterly installment will start from the date of payment of the first installment. So people will obviously now they'll start paying and they'll apply for the amnesty. So that we didn't disclose to him in the meeting, but this is the fact. People will not come forward to pay amount early. No, they will try till the wait till the last week, maybe last. But I will request not to wait, because yesterday we faced problem in making payment in our office. The payment was about 1 crore 20 lakhs, and we made a payment. Client made a payment, and challan didn't get generated. Then we approached Mahavikas. They said that we'll try. Bank says that amount will be credited to the account. This all confusion arises at the last moment. So it is better to do it in time or before time. So we have requested the commissioner to extend the amnesty, but he says that there is no good response, so we are not going to extend the amnesty. There were some incidental issues which were there, that the record is not with the first appellate authority. Unless the first appellate authority decides the matter, we cannot go in amnesty. These all things were there, but he says that now there is no point in discussing. Now amnesty will get over, and we are not in mood to the extend the amnesty. But our president has good political connection, so we hope that we will get that the help from president to extend the amnesty. We are going to try it at our level best. So let us see whether that amnesty gets extended or not. But these were the points, and the important point that we mentioned, or we represented the commissioner regarding the ex parte assessment orders, wherein the ex parte orders, we have requested them to remand the cases back so that the liability will be crystallized. And in some cases, when the Anshul Olympics of the Nagpur bench was holding the field, some appeal cases have been filed without 10% part payment. And this 10% part payment, the cases in which the 10% part payment is not made, we are requesting them to admit and remand back to the assessing authority. Now they themselves have requested us to tell us the legal solution, because they don't want the people who are not entitled, or the people who do not deserve this benefit should get this benefit. So we have requested them only in cases of ex parte orders, where people have filed appeal without 10% part payment. You remand these cases back to the assessing authority so that they can get benefit to hear the cases on merits. So they are thinking positively. Let us hope. We think that we are going to get a positive outcome to that representation. With this, I think I have appraised all the points that I had to appraise. Thank you, President, for giving opportunity, and I thank our today's speaker for sparing his important time and going to enlighten us on the topic. Thank you so much.
Now I request our Honorable Secretary, Sri Vinod sir, to introduce Advocate Deepak Bapat sir.
Thank you, Sumit. Today's speaker, Advocate Deepak Bapat. Since 1981, he is exclusively practicing on sale tax, VAT, now GST matters before appellate authorities as well as tribunal and high courts. He is a founder president of the Advocate Tax Bar Association registered in Delhi, which has recently commenced its activities. Presently, he was a member of AFTP, Indirect Tax Law and Representation Committee, and also member of the National Executive Committee during the year 14-15. He was the president of the Sale Tax Practitioner Association of Maharashtra during the year 2007-8 and 8-9. He was also the president of Sale Tax Tribunal Bar Association Maharashtra during the year 14-15, 15-16. He gives the lectures, writing articles and paper on GST. He represents various business organizations before the government on GST issue. I welcome Advocate Deepak Bapat Sahib. I request our president to offer a memento. I request Bapat sir for his further proceeding.
President of the Goods and Service Tax Practitioners Association of Maharashtra, Mr. Praveen Shinde, the chairman of the Law and Representation Committee of this association, Mr. Dinesh Tambe, convener of this Law and Representation Committee, Mr. Sunil Joshi, and newly elected secretary of this association, Mr. Muske. And above all the persons present over here for this meeting, physically as well as virtual. Friends, the topic which is allotted for this study circle meeting is the amendments made to the GST Act effective from 1st October 23 onwards. In a way, from 17, we all are aware that GST law is such a law whereby we can say daily there are either amendments or clarification by way of issuing circular. So even if we keep daily times, that also will fit to this topic. Friends, I will start with the amendment 2, the cancellation and suspension of registration. You are aware that before a year or so, it was started with COVID, I can say. There were large number of suspension and cancellation of registrations. There was amnesty scheme also introduced. Those who missed the bus for filing the application for revocation of cancellation, that also gave a good response. But still, there are some issues, and some amendments are made to these some of the provisions of that. As far as these two provisions are concerned, Section 29 deals with cancellation and suspension, and Rule 21A deals with suspension. Rule 21 deals with cancellation in certain cases, such as violation of provisions. And Section 30 and Rule 23 deals with revocation of cancellation. As far as the amendment is concerned, the reasons which were there for making the registration certificate to suspend it rather before cancellation, that is the step taken, can be taken. This scope for suspending registration certificate has been widened. Now, suspension can be on the basis of comparison between GSTR 3B with the GSTR 1. Means my outward supply shown in GSTR 1 and GSTR 3B. And the second one, the details of inward supply derived from outward supplies of, say, a registered dealer's GSTR 1. Means my, in short, inward transactions will be compared with the GSTR 1 filed by my suppliers. As you know that earlier, in such cases, when the purchases are suppressed after this comparison, then also they were treating it as a suppression of sale as well. As you have suppressed purchases, there must be suppression of sales as well. Or on such other analysis carried out on the recommendations of the council showing significant differences or anomalies indicating contravention of the provisions. All these things may come only by comparing the return filed in form GSTR 3B with the GSTR 1 of both. Now, such analysis or contraventions or comparisons which may lead to cancellation of registration or on failure to inform bank account details as per Rule 10A. You are aware that if one bank account is attached, the people are opening the other one. Or if it is genuinely closed, then also they are not informing. So such non-informing to the department about the bank details, that also may invite suspension of your registration. Now consider the case like this. In case of appeal filed beyond 4 months, assessing officer attached bank account on the ground that appeal cannot be allowed. When I made the officer concerned, I said, was that 10% amount is deposited? Section 1077 clearly says balance amount shall be deemed to have been saved. Officer started arguing that, but you know that appeal is filed after 4 months. I said, why you are sitting in the chair of the appellate authority? That is not your job. What will happen to those appeals later on? And so for that, you must detach my account, which was already attached. When that matter came to me, it was already delayed. Then I filed the appeal and I made that concerned officer. But the officer said, no, I am not going to detach. So far, so good. As I said, as I was on Rule 10A, as usual, what the client did, he opened another bank account. He started working on it. And now, what will happen, that we'll have to see. As he opened new bank account, the question is, can his RC be suspended or cancelled for not informing details of new account as per Rule 10A? Now to this, as we have been informed now that our commissioner has played a major role to deal with the issue of delayed filing of appeals, which cannot be condoned if the appeal is filed beyond 4 months. Now, therefore, in this 52nd GST Council meeting, recommendations are made, announcing, declaring amnesty scheme in case of such appeals, which are delayed beyond 4 months. In short, what that scheme is, against the demand order under section 73 or 74 passed on or before 31st March 2023, or whose appeal against the said order was rejected solely on the ground that it was not filed within the time period prescribed, specified under section 1071. Now here, basically two issues arises. First one is, what will happen to those orders which are passed after 31st March 2023, because even thereafter the position about online appraisal of the recipient, means dealers, was also not good. Still, so far so good. This amnesty will be applicable only for orders passed up to 31st March 23. Now, what about delayed appeals filed against order passed under other sections? There are two issues. They say that the order passed under section 73 or 74 only. But as you are aware, that the appeal can be filed against any order or any decision taken by the authority. So attachment of a bank account, that also, there is no necessity that the order is passed under section 73 or 74 only, or say application filed for registration, which is delayed for some fancy reasons. We are facing every time when we apply for registration. Against that order, if no appeal has been filed, what will happen? You are out, because sections amnesty scheme, which is in pipeline, says orders passed under section 73 and 74. And about orders passed thereafter, that is 1/4/2003, what to do now? My answer will be struggle will continue, not to give up.
Yes.
The scheme provides that filing of appeal will be allowed against such orders up to 31/1/2024. Means for any reason, such appeal, which is already delayed by 4 months, even if I file it today, any time before 31st January 24, that also will be admitted. But that is subject to condition of part payment of 12.5%, out of which at least 2.5% should be in cash. Means 10% can be paid by debiting the balance in ITC ledger. That is the basic purpose. In short, additionally, one has to pay 2.5% instead of 10% in case of normal appeals, which are in time. To knowing the intricacies, whatever we have expressed only for the out of one paragraph of the amnesty scheme in the gist of that recommendations made in the 52nd GST Council meeting. This is the narrative. So better to wait for that notification to come. Now I was on a point regarding the suspension, and when the bank account which dealer is opening out of course, because many a times the bank accounts are being attached for non-legal reasons as well. Now the bank account is attached. Now I am before that officer again saying, now the attachment should be detached now. Now he said, now I will think on it. But still, once there is attachment, it is difficult to get it detached. And every now and then, if I go to the High Court, immediately it will be detached for the reason that the appeal is pending. High Court is not going into the merits of the case for such reasons. But so far, so good. The fact remains, as we are on the point of suspension of registration, that the change in accounts was not informed in such a case. Now, the next point. Registration shall be suspended and after intimation in Form GST Reg 31, highlighting the said differences, anomalies and non-compliances, asking him to explain within 30 days as to why his registration shall not be cancelled. But our experience is what? If the officer feels that this is a case fit for suspension of your registration, they send the notice, but along with the notice, they suspend it also. That is our experience. Then why this farce of a notice? In such case, High Court is coming very hardly on such attitude. 2 days before, you must have seen the order of the High Court, whereby in spite of making representations to the authority concerned, the action was taken. And there was no answer with them. So this is a mess as on today. So if the suspension of the registration is to be done, the officer must give you the notice in Form GST Reg 31 and then should take a decision, because you know that for all practical purposes, even though registration is not cancelled but only suspended, then also it amounts to as good as cancellation of registration. The bad effects on us that has been explained hereinafter. Now there is one more deeming provision about the revocation. What is that? The third proviso is inserted to subrule 4 of Rule 21A, where registration is suspended under subrule 2A for non-compliance of Rule 10A about not informing the bank details. In such case, if the notice might have been given, but if registration is not yet cancelled, suspension shall be deemed to be revoked upon compliance under Rule 10A, means furnishing of bank details. So that is a welcome provision, because otherwise we would have required to chase the officer concerned that compliance has been made, so kindly revoke the cancellation or suspension order. Now this is about revocation of cancellation of registration certificate. Only some of the short points, because that revocation many of us knows very well. Subrule 1 is amended by substituting some words. It provides that after RC is cancelled by proper officer on his own motion, registered person may, subject to the provisions of Rule 10B, means that is a big problem nowadays now, authentication of Aadhaar, submit an application for revocation in form GST REG 21. Now the time limit, which earlier was very less, that has been increased to 90 days from service of cancellation order. Moreover, as per first proviso, aforesaid time can be further extended by the commissioner to 180 days. So that power is given to the commissioner, which can be delegated by him to the additional commissioner or joint commissioner by passing the order of such delegation. And that extension of that 180 days time further, that of course depend on if the commissioner is satisfied that such circumstances exist. So earlier, as you are aware, when the time of COVID, that was extended by the commissioner. If we show some other reason, then that period can be further extended. But the real problem is when the registration is suspended or cancelled, basically why we want the extension. That should be, we should take the opportunity very quickly to file the application for revocation of cancellation of registration certificate. But we come across many of our clients. They say that if I apply today for revocation, then immediately I will have to pay all those taxes. And that is why we again and again pray for the extension of the time. But that is not a good scenario, because there are bad effects, as I said, of the cancellation of registration. Now, as far as that amnesty was concerned, that was for the late filing of appeals. Now, for this, there is no amnesty. Whatever you find over here, that there is no provision to protect the interest of such persons and their customers during intervening period. Means my registration is cancelled today and revoked, means restored after say 6 months. What about intervening periods? I may lose my ITC because of invoking of section 16(4). Interest and late fee for returns filed after revocation. Because when some facility is given, at that time it is also necessary that consequential interest and penalties or the period required, that also is required to be extended. Because court normally goes, we have seen such orders. That revocation, yes, amnesty scheme was introduced. But about interest, nothing was there in the amnesty. So all such problems are going to be occur. So I suggest, now fortunately we have the chairman of this Law and Representation Committee in front of us, that whenever you give any concession, at that time the consequential effects thereof also should be given. As far as interest is concerned, I do understand, because taxes are admittedly paid late. But about 16(4), there must be a concession. Because ultimately the taxes are paid, returns are filed. Now the recipients are also the sufferers for denial of ITC, because when my registration was cancelled, I get it revoked or restored later on. Then customers in this during this intervening period may not get the ITC. Therefore, RC cancellation is a bad policy. This is my opinion, because in case of genuine persons who fail to file returns, because for not filing of the returns, there are so many reasons. I do not say that no punishment, they should not be punished for not filing the returns in time. But by cancelling the registration, sometimes you are helping those who are non-genuine persons or want to take the undue advantage of this. And moreover, when I am not filing my returns, when I am not making the payment of my taxes, why to cancel my registration? By that, there is a judgment on this cancellation issue heavily coming on the policy of this, by saying when you are cancelling the registration, you are taking out such dealer from the stream of those who are collecting and paying the GST to the government. So that whatever my opinion is, I have opined for, apart from whatever I submit, why my registration should not be cancelled, because for this reason or the other, mainly financial reason, I am not in a position to file my return. No registration should be cancelled, because all other issues are open to you. But for that reason, I am saying cancellation of registration cannot be used as a punishment to those who are filing the returns late. Now, the another difficulties are, from recipient's point of view, granting new RC to non-return filers is bad impact. I explained to you earlier that after the registration is cancelled, the person whose registration is cancelled, ठंडा बैठा हुआ है, पैसा यूज करने को मिलेगा. This is one case. Another case is, once that registration is cancelled, then as far as such dealer, if there is no ITC to him, looking to his nature of business, he is not going to get ITC even in the absence of cancellation also. Then in that case, if we tell them that we have to go in appeal or say writ petition in a particular case, they say no, we are going to file the new application. And that particular administrative officer of our area said, you apply newly, we will grant you new registration. Then as a result, what will happen? Now suppose I am a purchaser. My ITC will be denied for the simple reason that my supplier's RC is cancelled. Now, in such case, what I do? The cancellation of registration of my supplier, because whenever I have filed one of the appeal, in that case, reason was what? His registration was cancelled retrospectively. Reason was again on the ground that for the last 1 year, no returns were filed. I told my client that I am filing the appeal now, but you are primarily out because no returns have been filed by him and his registration is also cancelled. In such case, whatever the stand I take, the stand what I take is this, that though his turnover was exceeding that limit, why you cancelled his registration? Non-cancellation, the cancellation of registration should not be a policy. And moreover, now you are granting him new registration. In such case, what I do, in addition to filing of appeal, I am chasing the principal or chief commissioners of the respective zone for restoration of my supplier's old RC and cancelling new RC which is granted. In Marathi we say, नाक दाबल्याशिवाय तोंड उघडत नाही. त्याच्यामुळे हे प्रयत्न तुम्ही केले नाही आणि सिम्पली अपील फाईल केलं, काय उपयोग? ITC तर मिळणार नाही. ऑफिसर सिम्पली विल से, look, no returns have been filed and his RC is cancelled. Even today it is cancelled. There is a big Sakhar sugar karkhana who has done this, means supplier of my client. And in that case, I am chasing this. Why that second RC was granted to him? In such case, the department should pursue rigorously filing of returns by the supplier. In short, while dealing with such appeals for denial of ITC to recipient, don't give up and try smartly. In routine manner, filing of appeal will not serve any purpose. Now see one more issue about appeals. Because of payment of GST by suppliers of rectified spirit, that is popularly known as. In this case, in such cases, I would say, what will happen? What has happened? And why this amnesty, why this recommendation has been given? That say, I am alcoholic, means liquor manufacturer. I have purchased rectified spirit, on which even after the introduction of GST in July 17, somewhere in 2018, there was one more schedule entry introduced, which otherwise was only for petroleum products and that which are the second item. Whatever is there, liquor is there in VAT. This third commodity was introduced as a VAT commodity. There was a separate entry for rectified spirit. As a result, what happened? As a liquor dealer, those dealers were registered under VAT. They were paying VAT on the sale side. And their purchases were by paying VAT at 20%. So obviously they took the ITC for that. Later on, what the suppliers did, they have been given advice that this rectified spirit, which is not a liquor, but that is a raw material for making a liquor. And that's why you should have paid GST. And the schedule entry, which was introduced under MVAT Act, that is bad enough. And therefore, what they did, they suppliers filed writ petition to the high courts saying that VAT entry is unconstitutional to definition of goods after the introduction of GST. And therefore, we have paid GST, though collected VAT from the customers. As far as customers, means liquor manufacturers are concerned, what happened? The ITC was denied to them, and all that 20% means crores of rupees demand was there. In such cases, as a purchaser, all those filed the appeals. Even I have filed 7 writ petitions, not appeals, 7 writ petitions to the High Court saying, if ultimately this honorable court held that on rectified spirit, which I have purchased, GST is payable, then in that case, to me as a purchaser, I paid 20% VAT and I claimed the ITC. But at no fault on my part, if this entry is declared as unconstitutional, in such case, either ITC should be given to me, just like under earlier law, entry tax ITC was being given. Either you give me the ITC or come out with the government resolution, which was given earlier, when any decision was gone against the dealer for so many years and there was statutory misguidance. In such cases, by that government resolution, in one kind of amnesty scheme only, the assessee used to pass the order by levying the taxes and penalty, means in this case, say, by disallowance of ITC. But later on, the government resolution which came out under those times is that such amount which is for which assessment order has been made have been paid by the government, another department. Ultimately, the purchaser was not the sufferer, or even in case of statutory misguidance, seller was also not sufferer. By that way, both the petitions filed by the sellers as well as the purchasers, those have been ultimately admitted by the High Court as far as recovery is concerned, not admitted, but the stay has been granted to both. And now we are seeing the result. When those matters were coming on board, As far as I was concerned, I have made up my mind very clear. Unless the petition is decided by holding that GST is payable on the rectified spirit, I have nothing to say. Because then only I can say I was statutorily misguided. But those are pending. And even before the Supreme Court, again the order of the Allahabad High Court, it's similar matter, holding that GST is payable on that. So that matter, such matters were before the Supreme Court. So on other day, the advocate who was representing those liquor manufacturers association, he included in those petitions before the Bombay High Court and said, kindly wait till the Supreme Court decides the issue. High Court obviously said yes, whatever ultimately Supreme Court will hold, that I will have to follow. So those petitions are pending. Now that problem will be solved. How? That now it is decided that rectified spirit will be outside the scope of GST. So VAT entry will survive. And in that case, what will happen? Even though they have paid the GST, they will have to claim refund of the GST paid by them. And they have to pay VAT now. So ITC disallowed to purchasers shall be granted. So in short, by putting these two cases together, I have achieved two things. First one, the amnesty, which is not amnesty, the concession or the decision which is going to come, that on the rectified spirit, there will be no GST but VAT. And secondly, as far as so far so good, we have heard right from 2012 about ITC disallowance, and that is going on day by day. But in case of genuine purchases, if the ITC is disallowed, in short, do not give up. With this, I will move to the next amendment, that is amendment to Rule 43. Rule 43 decides about that is the manner of determination of ITC in case of capital goods. In this case, kindly see the second bullet. Explanation 3 is inserted to Rule 43(5) to provide the value for the purpose of Rule 42 and 43 in regarding what? That value. Supply of warehouse goods to any person before clearance of home consumption. In short, in our layman's language, that is IC sale. You are aware that IC sales, after the initial hue and cry, whether that will be taxable under GST or not. That's why they were included in Schedule 3 in Para 8A. Now, in such case, when the computation, as far as Rule 43 is concerned, for including the same in the value of exempt supplies under Clause B of the explanation to Section 13(3), where Section 17(3) speaks about the ratio of the goods used, means which are for exempted manufacturing or sale or untaxable. In that case, that value shall be the value of supply of goods from duty-free shops at arrival terminal in internal airports to the incoming passengers. Now, I really fail to understand what is the purpose behind making this amendment, because in case of IC sale, there is a value. Then why the lawmakers now think that that value shall be the one determined on the basis of the goods from supply of goods from duty-free shops at arrival terminal? I do not understand the rationale. If anyone come across, then please speak to me. Yes, and yes, that is correct. When yesterday we were debating, me and Sonali. Now, when the price is being compared with the goods supplied from duty-free shops, as a general layman, have we seen any capital goods being sold from duty-free shops? Then why? That is the another question. Now the next issue is, the amended issue is interest on delayed refunds. As you are aware that if there is a delay in granting the GST refund, then the provision was already there in Rule 94 to pay the interest on the refund which is delayed. Now, what the amendment is that the present section, present rule has been numbered as sub-rule 1 of 94, and sub-rule 2 is inserted to provide that following periods shall not be included in the period of delay. In short, what they want, that there may be a delay. Now, because of the law made, we are forced to give you the interest of the refund. So wherever you are in fault, either giving the reply, which are specified, which you can go through. So I'm not reading every word therein. That whenever there is a delay from your side, that should be excluded while counting that interest on it. That is the purpose behind adding sub-rule 2 to Rule 94. Sometimes what happens, even for validating the details of bank accounts, there may be a time. At that time, most of the time for that validation, the portal takes time. And we have to visit so many times to the proper officer to get any solution. Still, that delay will be held on your account, not their account. Now, this is one more crucial amendment regarding procedure for compounding of offences. First of all, compounding of offences in a case where the sailors who got their registration cancelled for their benefit, in such case, if the offences are compounded, then there is no threat to them for prosecution. So, such should not have been happened. They have taken the care in it. But now, as you are aware, that any client which was coming to you, those basically was or is mischievous. Before you and I come to know, they were coming to know about it. सब मेरे पास रेड आया, लेकिन 5 crore तक, earlier it was 2 crore something, वो prosecution नहीं है. So these some of the concessions are given for such people or not, that we have to see. In sub-rule 3, the words has occupied in the proceeding before him. Has cooperated in the proceedings before him. What this kind of cooperation? Please do not ask. But now those words are removed. He may cooperate or not. If other conditions are satisfied, then offense can be compounded and he will get immunity from prosecution. The commissioner, after taking into account the contents of the application, because for compounding, one has to make the application in the form which is in front of you. Then the commissioner may pass an order in this form CPD 02, either by granting immunity from prosecution, indicating the compounding amount, or reject such application within 90 days. So this is the provision in short. But that one thing is good. If we go to that table later on, we'll find that the fee for compounding is as good as equal to tax. That we'll see later. The commissioner shall determine the compounding amount as per table, provided where the offence falls under more than one category specified in the table, the compounding amount shall be the amount for which higher compounding amount has been prescribed. Means, in short, 2 or more offences that will be punished more by way of having the maximum amount for compounding. Now, if we see this table, here the amounts for compounding are up to 75% of the amount of tax evaded, or the amount of input tax credit wrongly availed or utilized, or the amount of refund wrongly taken, subject to minimum of 50% of such amount of tax evaded, or the amount of input tax credit wrongly availed or utilized, or the amount of refund wrongly taken. Now, this is about the cases here one by one. I need not go, but you can see that 75% of the tax which is tried to be evaded, etc., that will be there. And below that, amount equivalent to 25% of the tax evaded, where offences specified in clause F of subsection 1 of section 132. In short, I am not going in detail because that is one has to read it when actually the issue of compounding comes. But that depends on the severeness of the short payment of tax or the offence committed. Now the section rule thereafter is about sharing the information. Here again, I am puzzled little bit. That earlier also they were sharing the information to the other departments. Then what for they now thought to come out with this provision? They need a consent from a dealer concerned, from a registered dealer concerned, whether about sharing that information. Where a registered person opts to share the information furnished in a Form GST Reg 1 as amended from time to time. Now, the reason is obvious that when I am declaring the list of my customers, and that's why they need a consent. Now, return in Form GSTR 3B for certain tax periods. Form GSTR 1 for certain tax periods pertaining to invoices, debit notes, and credit notes issued by him as amended from time to time. Now that form has to be signed, maybe yes or no will be there, with a system referred to in subsection 1 of section 158A. The requesting system shall obtain the consent of the said registered person for sharing of such information and shall communicate the consent along with the details of tax periods where applicable to the common portal. The registered person shall give his consent for sharing of information under clause D of subrule 1. What that clause C is? That is regarding my customers' transactions. That's why while sharing that, when I am expected to give my consent for such sharing, only after he has obtained the consent of all recipients to whom he has issued the invoice, credit notes and debit notes during the said tax periods, for sharing such information with the requesting system, and where he provides his consent, the consent of such recipient shall be deemed to have been obtained. In short, that responsibility is casted on the seller. When the seller is giving consent to share the transaction of my sales, mean their purchases, from me of rupees so and so, then at that time, I am supposed to obtain a consent. And only thereafter I will give that consent. And even if I share that one, allowed to share that one, then it will be deemed that I must have obtained the consent. So they cannot complain why that information was shared. That will on my head. As you are aware that sometimes when the investigation or raid takes place, many dealers face sometimes more problem than from their customers or suppliers than the officers concerned. Why? अरे यार आपने पटाया नहीं इसलिए हमारे पास आ. So that is why about the sharing they want a consent. There must be something behind this. Now the common portal shall communicate the information referred to in subrule 1 with the requesting system. Say for example, GST2 requesting system is say income tax department. On receipt from the said system, A, the consent of the said registered person and the details of tax periods or the recipients, as the case may be, in respect of which the information is required. Government is inching very fast towards sharing taxpayers' information with other tax departments. So, in short, the caution what we have taken that I have narrated over here. So while sharing the information, kindly take care. And most of the time, what happens? In a hurry or with some not a good motive, we file our return. And if such information is given, then that will be bouncing back on us while giving that information. And that also about third party. Because I made a mistake while filing that form. And that I am sharing with him, which that transaction is not done by him with me, or may not be of that amount or of that date. So one must be cautious. That's why I showed in the last bullet. With this, another amendment is now you look here. That section 23 of the Finance Act 2021. That is being made effective now from 1st October. Then really when I sat down to rather gather what those amendments can be. At that time, I looked to this and I came across, as you know, that we always keep a watch and we are aware of such things that that particular section is not yet made effective. But still, after downloading this, what we can see is section 16(1) of the IGST Act defines the meaning of zero rated supply. This is for the general information of we all. Clause B, the words for authorized operations to SEZ, etc. are inserted. The reason is why normally when I make a zero rated supply, means one of that is to SEZ. Earlier there were cases when I have sold something to SEZ. Practically speaking, why should I see for what purpose he is purchasing that? The smart officers were making the queries in GST departmental audit that these are the purchases made which are not for their official purposes for which they were supposed to buy from you at zero rate. And that is why now as a precaution or rather to make it specific, that such supply should be for authorized operations. And for that purpose, while selling this, better way would be to obtain that certificate from them, which declares them as SEZ unit or SEZ developer. So the scope of harassment to the supplier concerned may not be there. That should be a precaution. Otherwise, every time there is a judgment of Bombay High Court also on this issue, that one particular form is issued. This is one kind of form only. That the purchaser is saying that I am SEZ and the goods which I am buying from you are for authorized operations. So that particular High Court decision said that seller should not be punished for that. That is his job. When he is purchasing something, that he has to see that he has purchased at concessional rate, in this case zero rate, though he was not supposed to. But still, as a caution, it is good for us. But and you also must have come across many cases where if you ask anything to your customer, they say, even in a case where the certificate of export in case of HCOM, etc., is required to be given by the purchaser who is the actual exporter, they say मेरे को देने वाले बहुत है, ये क्या पूछ रहा है? So for that purpose now, when these words are specifically now included, that the such supply should be for authorized operations of SEZ. The job of the seller may little bit become easier. He can ask for the details from that. Otherwise, even if he purchased, as I given here, the gift hampers and many other things or any gift articles which are not meant for authorized operations, then also the unnecessarily the seller may come into it. That is in short. Now, as far as section 3 is concerned, a registered person making zero rated supply shall be eligible to claim refund of unutilized input tax credit on supply of goods or services or both without payment of integrated tax under bond or letter of undertaking in accordance with the provisions of section 54 or the rules made thereunder, subject to such conditions, safeguards and procedure as may be prescribed. This is nothing new. This is as good as means production of the bare provision. This is important. This proviso is, as far as this proviso is concerned, that was basically inserted. What that proviso in short says, that such supply when made to the by way of zero rated supply of goods, in case of non-realization of sale proceeds, be liable to deposit the refund so received under this subsection, along with the applicable interest under section 50 of the Central Goods and Services Tax Act, within 30 days after the expiry of the time limit. In short, why this proviso? If no sale proceeds is received, but normally the definition of export says what? Exporting the goods from one country to another country. So we may say that I am the exporter. I have exported the goods. I have taken the refund. But if it is proved that we have seen in the earlier proviso that no sale proceeds are received, then as per that proviso, whatever the refund is taken by us has to be refunded along with the interest. That's why this amendment has been done. This I have already explained to you. So now the receipt for the export made. Such problems in case of export of service we always face. That when the payment is received not one by one, it is received in lump sum. Many of the authorities are on frivolous ground that that payment is not matching with the export of services made. For that, there were judgments, there were CBIC circulars as well, but the authorities were doing. And therefore, in such case of refund also, one has to look carefully and submit the details in writing by saying that this payment can be applied first come first sold basis as well. Ultimately, receipt of payment is important. Class of persons and class of goods for export with payment of tax. The government may, on the recommendation of the council and subject to such conditions, safeguards and procedure by notification, specify a class of persons who may make zero rated supply on payment of integrated tax and claim refund of the tax so paid. Here kindly mark the words in this Roman 1, class of persons. Those will be notified. And second one is class of goods or services which may be exported on payment of integrated tax, and the supplier of such goods or services may claim refund thereon. But till today, no notification is issued to specify the class of such persons. However, in case of class of goods, there is a notification, this notification to notify all goods or services except the goods specified in column 3 of the table mentioned in the next slide, like pan masala, tobacco, gutta, etc. whatever the goods are mentioned therein, in that case, such refund cannot be claimed. Barring that, so that's why the notification as far as goods are concerned, that has been issued to make them out of this provision. But as far as class of persons is concerned, that is not so notified. This is what it is that I have already explained. So one has to see whether the export which is being made is not falling in this table. If you are falling in this table, then that cannot be with tax and claim the refund. Yes, you were asking.
So I have one question. Now that mandatory to have a LUD is better mandatory. So there is a one condition that in case of constitution having a tax amount of more than 4.5 crore, we cannot be eligible to allow LUD. So in this case, for example, any of my client or somebody is having a tax emission of more than 2.5 crore, which is not falling under the class of goods or class of person, class of services. So how should we will do export?
Where is that condition? Kindly tell me again. Where there is a
For availing LUD, there is a condition. If a dealer should not have a tax emission more than
tax evasion.
Yeah.
I was under the impression.
tax emission.
Yes, yes.
So, because it is not clear, because there will be some person who is having a tax emission. So by default, he has to make LUD only, right? So what is the solution?
This matter will fall under litigation in the sense, because when I was reading that table regarding compounding of offenses also, there everywhere the word also use this evasion. Now suppose that suppose there is a demand in a case where ITC is disallowed, where you say, means department says that it is always they say it is purchased from non-genuine supplier, but there is a difference always you have to take into account. The non-genuine purchase is different than purchases from non-genuine supplier. So always make it a point whether the purchases made by you are declared by passing the order that they are bogus purchases. If they are, yes, there was the evasion and the LUT not granting beyond a certain limit would be right. But here again, on this point, you have to face those authorities that evasion has to be proved, that there was the attempt to evade. These are the just explanations about the heading and sub heading tariff, etc., given in the table about those goods. These are again as you are aware that as far as the excise tariff or HSN have been mentioned, these are the explanations regarding. These are the general rules nowadays. Under VAT, only limited issues. But under GST now we are habituated to read those rules given under the respective notification, how to classify that particular item under the respective entry. Now, as far as electronic commerce operators are concerned, this notification has been issued who is required to collect tax at source under section 52 as the class of persons who shall follow the special procedure in respect of supply of goods made through it by the persons paying tax under section 10 of the said goods. Now, this is one kind of composition scheme only, or one of the condition that may be. I will have to read it again. That to notify the electronic commerce operator who is required to collect tax at source under section 52 as the class of persons who shall follow the following special procedure in respect of supply of goods made through it by the persons paying tax under section 10 of the said act, means those are opting for composition. The electronic commerce operator shall not allow any interstate supply of goods through it by the said person. The electronic commerce operator shall collect tax at source under subsection 1 of section 52 in respect of supply of goods made through it by the said person and pay to the government as per provisions of subsection 3 of section 52 of the said act. The electronic commerce operator shall furnish the details of supplies of goods made through it by the said person in the statement in Form GSTR 8 electronically on the common portal. This is welcome provision, as I understand. Till today, there was no provision of paying tax by way of composition to e-commerce operator. Now, limited to this, when the supply made by the electronic commerce operator of those suppliers, means on behalf of those suppliers who are under composition scheme. Excluding that, for the balance one, the composition scheme is applicable to such e-commerce operator, who is a small one according to. Now, this is the rule made to prescribe a form and manner of submission of statement of supplies through an e-commerce operator. This, I don't think there is anything new. Now, friends, as far as the amendments till the means about e-commerce operators are concerned, till then, I was in a position to cover till 3 past 15 minutes. Now, as far as the online gaming is concerned, that is entirely the new subject. And that is why in this PPT, which will be shared to you all by the association, all these provisions have been narrated properly one by one. And as this is a new levy, I have not come across, means I have not studied rather, the intricacies there. As a student, I have only jotted down those provisions regarding online gaming. More of us now must have read in the newspaper that the notice is given to this actor or that actor. Barring that, only because this topic was allotted to me, I rather at least studied those provisions and jotted down for your benefit. And with this, looking to the time concerned granted to the study circle meeting, I think when I gathered all those information, I thought, and that is the real fact, apart from online gaming, the earlier amendments, whatever we see, are not too many. But of course, I try to make them interesting by reading out before you the whole provision, like suspension and cancellation of registration, etc., and regarding the interest payable on the refund, etc., whatever I at a glance recollect. But with this, I think we should conclude this lecture. And at the end, I thank all the participants present over here, online and offline, nowadays language. And the reason president is here, in a case where they knows that for the study circle meeting, now there is no crowd as such. And this I came to know when I started reading those. Initially, I told Mr. Sunil Joshi that let me go through which are those amendments. I was going to Pune tribunal and he gave me a ring that whether you will take up this. I said, at least let me see which are those amendments I will say. But my name was declared. I saw the email that was declared, but I must thank them. Because of that, at least I study those which we, as an advocate, you must be knowing. Unless the fee is paid or assignment is given, no one studies. So now that brief was given to me, I studied them. And later on, when I saw the status of our President Praveen Shinde, much importance was given to the Malad Chamber seminar. So I thought, why to study this online gaming now? So your own president knows that that seminar is important. These topics are not important. So I am stopping over here with the expectation that this boycott or exclusion of fine should be stopped now. Tiger abhi bhi zinda hai. Thank you.
प्रत्येक सेमिनारला प्रत्येक ऍक्टिव्हिटीजला म्हणजे इव्हन जो कोचिंगला असो स्टडी सर्कल असो किंवा इंटेन्सिव्ह असो वर्कशॉप असो त्या फोरमला बापटसाहेब आपल्याला मार्गदर्शन करत असतात. असं कोणतंही इंटेन्शन नाही बापटसाहेब की आमच्यामध्ये की मागे काय झालं ते आपण पुढे जाऊया आणि चांगल्या पद्धतीने सेमिनार करूया त्याच्यापुढे हे मी सांगू शकतो. एनी क्वेरीज फ्रॉम any question answer? Ravi, Sonali. There is a question about. I will request Roshi sahib to give the queries which are live online. Yes. So there's a, hello. Yeah. So there's a question by Mr. Mahendra Jain. He is saying my dealer has purchased goods from a supplier and took ITC. After a department cancelled the supplier GST Law. But when my dealer has purchased the goods from the supplier, I'm just struggling to get it. ओपन का होत नाही कट का फोन करून माझे एकदम पुढे जात तिकडे घे ना चॅट तिकडे काय. Any query for audience? I just
I think either I am right or I
right. Yes, you might.
either I am not understanding or I need your guidance. That e-commerce operator has given out to competition level candidate. So tell me one thing. E-commerce operator is generally a facilitator like Amazon, Flipkart, hotels, right? So generally, all they are not doing actually business. Or let's say XYZ person is selling goods on the portal. Okay. So obviously, it extended competition dealer are only in within the state of Maharashtra. So what is the intention they have restricted to industry, to e-commerce?
As far as any composition scheme is concerned, there are always such restrictions. Under the earlier law, there was a provision also that there cannot be any import in the sense purchases from outside the Maharashtra state also. Like that, according to them, the composition scheme should be given to those who are small also. And that is why one of the conditions is must have been given there that we should not be interested.
Because bigger kinds are e-commerce, but like Amazon or like Staples, they are not allowing to open a commercial dealer in the portal because the commercial dealer are not going to register with the Amazon or Flipkart. So there is still restriction.
Means as far as portal is concerned,
No,
no.
not portal. Commercial dealer are not by default to register with Flipkart. Only the regular dealer has to be registered with the Amazon or Flipkart. There is a condition.
But as far as that condition is concerned, whether as far as after publication of this notification, whether that one is there, such condition for opting for that will have to.
It can be the case like if he is registered on Amazon as a regular dealer and later on he has gone for compulsion dealer, then you may not know the situation that he is not a normal dealer anymore and he is a compulsion dealer. So that is a reason I guess so.
Yes, Maggie.
For that effective date is given, that is 1st October. Then, yes.
The export, the goods per realization is not there within a prescribed time. They will set the set of refund it to be returned. It is after 1st October applicable or past refund also.
As far as that amendment is concerned, that is made effective from 1st of October. So to my mind, it will be applicable only in case of transactions made thereafter. Yes.
Yes, sir. Coming to that online query, my dealer has purchased the goods from the supplier and took the ITC after department cancelled the supplier GST on SC Mtg. But when my dealer has purchased the goods from the supplier at that time, supplier number was active. He has also filed the form GST 1 and 3B. So now what is the recourse for? Any court precedents to helping the dealer on that?
The problem what I see in such cases is that for authority, it is always very simple to say that you have purchased the goods from RC cancelled dealers. That case becomes more worrisome when that RC cancelled dealer is declared as non-genuine dealer. So one has to keep in mind that first of all, you make your mind first, of course, from the basis of documents taken from our client, from purchases, that your purchases are genuine. Thereafter, you go and approach to the suppliers step by step. Suppliers, nodal officer, suppliers means principal commissioner of that area, and do not give up. That's why I give that example where the one registration was cancelled and another was given to him. Even though that may be exceptional comparatively, that one registration is cancelled, he took another registration. But many a times, that registration is cancelled for some technical defects as well. And the authorities say that that registration is cancelled, so for either purchaser, you will not get that ITC. In such case, always say there are judgments of the tribunal, yes. In Swami Samartha something, that name is there. In that case, on the very point, the tribunal has made, in such case, the proceedings of cancellation in case of that supplier must be shared with the purchaser. And as I said, if his turnover was above certain limit and still his registration is cancelled, then that Suresh Kadi Company judgment of the Bombay High Court, which was upheld by the Supreme Court, will come into play. that in such case for intervening periods transactions or thereafter, where the purchaser is not in fault, the purchaser should not suffer. He must get the ITC. But normally what happens, the portal has the supremacy. Portal ने दिखाया है ना उसने भरा नहीं. Portal ने दिखाया उसका RC cancelled है खत्म. But that should not be the case. Of course, what happens? You go to the quantum. If the quantum is big, don't give up. Because here even today, I have the think that is the sorry, that I am not intervening in the topic given for tomorrow's your important seminar. But ITC is such a subject that which comes anywhere, even though the seminar is not on ITC. So the same thing here, maybe for one of the topic which was there today, that in case of cancellation, one has to ask for the suppliers proceeding about that cancellation. I was, it is being said by the market people that I was only the one who has filed the writ petition in case of that Drushi trade outs, Manoj Dharmani, who was declared as a non-genuine dealer in under VAT. And all his purchasers were trying to call me when the petition was filed. The writ petition was for what? As a seller, why my registration cancelled? Because there was no order passed that or neither affidavit was given by my client saying that I did non-genuine business. So why that was cancelled and the High Court restored that registration certificate by that order itself. And only about suspicion, they said give them a fresh notice and they decide whether that name is to be kept in that non-genuine list or not. Nowadays, that is the TP, that is the term now replaced by the earlier one, which was earlier there for suspicious dealers. So one has to take into account by making a clear distinction between the genuine purchases and non-genuine purchases. Genuine purchases made from non-genuine dealer you must get the ITC, but if you try all such things, and that is why one more case I put before you, the recent case of the High Court, whereby whenever you make the representation to the department, say I'm equating that judgment with this issue, that when the purchaser complains that why you cancelled that seller's registration or why you have not chased non-filing of the returns from him, you have merely cancelled his registration certificate and kept him on and getting that money recovered from me as a purchaser. When that purchaser is making a follow-up with you, what for all the authorities were silent? They kept mum over there and said, now we look to this. So that is the answer.
Thank you, sir. Thank you, sir. Now regarding sir's today's lecture, I must confess that I got a golden opportunity to invite sir on a study circle, and I don't want to lose that. So I gone beyond my limits and declared sir name immediately because I don't want to miss. When I discussed with the sir, he said there are two things: the reading of the law and understanding of the law. So we all can read the law, but understanding can be given only by the experts. So today was the day. So we will understand the law provisions from the sir. Now I request Mr. Barram Vedari, our member, to propose hearty vote of thanks.
Thank you, GSTPAM and respected committee member, to giving me an opportunity to introduce our vote of thanks to Honorable Mr. Bapat sir. As said, ki tiger ab jinda hai. So I want to say few things as being, I think I'm just 38. शिकार तो सब करते हैं, लेकिन टाइगर से बेहतर शिकार कोई नहीं करता. I really inviting Mr. Bapat sir, please come and regular and give guidance to young people like us. We need always guidance from the seniors, even though we are techie savvy, but we think the pillars the base never goes wrong. So we need, even though I think we are go and technology we may sound, but we know unless until our base are not clear, so we cannot go and in a success mode. So we always need as a speaker like you and many people. So always welcome, and whenever you get time, you just guide us. And as far as your today's session, I think the changes are just recently has came up due to time limitation. You could not like online gaming or that e-commerce wala, but whatever you are assigned, that was really, like for example you said about that ITC that RC cancellation, that we have to you high court may you cross to that party. So I think being a practitioner, you not only safeguard your dealer, but the rest of the dealer, it will be the judgment when come, it will be beneficial to all. You are not restricted to your client only. Beyond, as a good advocacy or good professional you are invented. I think I think this is due to sudden. It has been granted to me. Otherwise, I could have done better. Thank you.
I will request all of you to arrange for tonight one.